although I provided Justice Feldman and earlier had provided Assistant District Attorney Donhauser with letters to me from the clerk of the Kings County Court, which unequivocally established that the term of my grand jury was from October 4th till October 29, 1976, and that the term of the grand jury had not been extended. Justice Feldman, in her November 5th, 2001 decision, ruled that the issue determinating grand jury records were lost, and that because of the loss of these grand jury records, she was applying the doctrine of presumption of regularity and denied my writ. So in other words, on November 5th, 2001, Justice Feldman's entire decision denying me legal relief was based on the false premise that the issue determinating records had been lost. Now, under the law of New York State, the district attorney is mandatorily bound to maintain these records permanently, and they cannot be removed from the district attorney's files. In addition to that, the district attorney had never at any time represented in any court, and particularly in front of Justice Feldman, that any of the issue determinating records were lost. So then, in an effort on my part to obtain release of the grand jury records and to force the district attorney to admit the existence of them, I initiated a civil rights lawsuit against District Attorney Charles J. Hines. In this civil rights lawsuit, I claimed that District Attorney Hines was impeding my access to the courts by concealing the existence of these grand jury records. Also, I raised the issue that he was not investigating or processing sworn criminal complaints I had submitted against both himself, Assistant District Attorney Caroline R. Donhauser, and Assistant District Attorney Phyllis Mintz for having concealed the existence of the grand jury records and committing perjury during proceedings in the state courts regarding the indictment forgery issue. During the course of the civil rights proceedings, District Attorney Hines admitted in the federal court that the issue determinating grand jury records exist, and exist in his files, the same records that Justice Feldman, in denying me relief in the state courts, had claimed were lost. So now, on the basis of these revelations in the federal court concerning the existence of the grand jury records, Attorney David M. Palmieri, on November 12th, 2010, initiated proceedings on my behalf in the Brooklyn court, raising the issue that these grand jury records did exist, and the fact that I was denied relief in the state courts previously on the erroneous premise that these grand jury records were irretrievably lost, that I was entitled to an evidentiary hearing and an investigation on the part of the district attorney's office to look into this forgery of my indictments during 1976. District Attorney Hines did not offer any opposing papers, and everything Attorney David M. Palmieri raised in this application to the state court remains undisputed. They have not in any way denied that they have possession of the issue determinating grand jury records. No assistant district attorney has ever denied that the grand jury indictment had been forged. No assistant district attorney has ever denied that the issue determinating grand jury records do exist. Nobody on planet Earth has ever denied that Assistant District Attorney Caroline R. Donhauser, in her affidavit of October 22, 2001, committed perjury in claiming that the grand jury had extended its term and that there had been a court order extending it that she claimed was lost. Nobody has ever denied that she lied when she claimed that the altered version of the indictment was voted by the extended term of the grand jury on November 8, 1976. So as things stand now, I remain convicted. Although my indictment was forged, although I am innocent, although the guy that committed the actual murder received a 3-year sentence, I served 32 years in prison on the basis of being innocent but convicted. There was also a $50,000 reward involved in this case. So as things stand now, the evidence against me was Dominic Vaccarino claiming that he was hiding 60 yards away and had seen me shoot the deceased. His brother, who was released from prison in New Jersey from a prison sentence which involved a house invasion at gunpoint, he was released from prison. His wife received immunity from prosecution for any involvement she might have had in the murder of the deceased, who happened to be her uncle. Ronald Spagna, whom at my trial presented an alibi defense of 9 witnesses who placed them elsewhere at the time of the crime, thereafter admitted to the murder in court, thereby showing that all of his alibi witnesses had committed perjury. He received a 3-year time already served sentence, and I served 32 years in prison. Now I'm able to make this video now because I appeared before the parole board 10 times. All 10 times I relentlessly maintained my innocence. On 9 occasions, I received separate 2-year hits from the parole board, mainly on the basis of my declarations of innocence. They wanted me to show remorse for a murder that I didn't commit. On my 10th appearance before the parole board, I continued to maintain my innocence. This parole board listened to me and they granted me parole. Since I've been out on parole, I have made it a mission to help kids make better choices in life. And I've been doing that. I've spoke at all the local schools in the Rochester, New York area. I have even been the keynote speaker for the New York State Division of Criminal Justice Services.